So I want to approach this issue of abortion from a different angle because much has been said the last 50 years and it's all pretty similar. We all heard the common debates around this, but there's actually a lot more to this abortion issue than just the morality of it. There are legal implications. There are a lot of nuanced opinions out there, but they're never really talked about because everything gets simplified down to, one side being these immoral, irresponsible baby killers, or the other side being these controlling, misogynistic tyrants. But, before we continue, maybe it's a good idea to set some sort of base, some sort of common ground that we could build this conversation off of. Because I think another way of looking at it is both sides are actually coming from a place with good intentions. One side genuinely believes that whatever is happening in a woman's body, it's her body, and is trying to protect that right and from government overreach. While the other side genuinely believes that that is a living being in the womb and is trying to protect life. So if we take a step back, those are good and virtuous intentions, not malicious ones. The other side aren't these evil monsters. It's just that the consequences of one's good intention is in conflict with the other good intentions. And so if we, understand that, then we could see that we could start unpacking this complicated issue through a civil discussion. And maybe some of you guys are thinking, yeah, that's easy for you to say, Isaac, you're not a woman. You wouldn't understand. Or the others might be saying, oh, you don't hold my religious beliefs. You wouldn't understand. And to a certain extent, you're right. I won't fully understand. But the point is that I'm trying. And that's the point of this podcast, starting right here with today's episode. Welcome to the Third Stage Podcast. I'm Isaac J. Kim, and today is a heated topic, so hopefully I won't get canceled in the very first episode. But as most of you guys probably heard, last year, June of 2022, there was a Supreme Court case called Dobbs versus Jackson Women's Health Organization. And the conclusion of that case ended up overturning Roe v. Wade. It didn't necessarily say that abortions weren't allowed anymore, but essentially gave it back to the states to decide for themselves. And this will probably be a good time to review what happened in Roe v. Wade, because most of the arguments in that case were basically the same in this Dobbs case. So in 1973, Norma McCorvey, aka Jane Roe, along with her lawyer Sarah Weddington, sued the state of Texas and challenged its law on abortion. Abortions were illegal in Texas unless the mother's life was endangered. Then, in an overwhelming 7-2 decision, the Supreme Court ruled in favor of Roe, which declared state bans and restrictions on abortion unconstitutional to a certain extent. They took on a trimester framework, and in the first trimester of pregnancy, states were not allowed to make any restrictions or bans. Then, in the second trimester of pregnancy, the states were allowed to enact some medical regulations. And in the third, states were allowed to create any kind of law, bans or restrictions. And the reasoning behind it was that's when the fetus is viable. And viability means when the fetus can live out of the mother's womb. And during the time of Roe v. Wade, that was about 28 weeks. But with modern medical advances, now that's about 22 to 24 weeks into pregnancy. Now let's break down the different opinions of the justices in this case, because this is actually where I think it gets really interesting. Most people think that Supreme Court opinions are black or white. You're either in favor or you're not. And while that might be true for decisions, it's not for the opinions. Justices may have the same decision, but their reasoning behind it may be different. So some justices believe that abortion was a constitutional right based on the 14th Amendment. Another justice thought it should be based on the 9th Amendment, but we'll actually come back to these amendments later. Another justice did not believe abortion was a constitutional right, but still ruled in favor of Roe because he considered it a medical issue. So it's not for the government to decide, but rather it's between the physician and patient. For the justices that dissented, or in other words, ruled against Roe, argued that there's nothing in the Constitution that specifically gives citizens the right to an abortion, and that states and legislatures should get to decide, not the Supreme Court of the federal government. So it's more than just a moral debate. There are people out there who are for abortion, but actually think that Roe v. Wade was a mistake because they believe that the courts overreached in their power when it overruled those state laws. And there are people who are actually against abortion from a moral sense, but still think that it should be allowed because the government shouldn't inject itself in a medical issue. Or each individual woman should decide for herself what's right or wrong. And there's also people with pragmatic views. It's not about right or wrong. They see it as abortions have and always will exist. And practically, it will only end up hurting the poor the most if you have these bans or restrictions, because they're the ones who can't afford to travel to another state and stay there for a few days and then travel back. So people have a mix of these moral, medical, legal values, and there's just a lot more going on here. There are three big legal issues at hand, and the first one is how much should be left up to the federal government versus the state government? And the second question is, what's the role of the judicial branch versus the legislative branch? And the last question is, how do we interpret the Constitution? Now, these questions have been debated since basically like the founding of our country. So, we're not going to solve all these issues within one podcast episode, but I think they're important to be aware of. So the first one of how much should be left up to the federal versus state governments. One could argue that keeping it on the state level gives citizens more of a direct say in the issues, because you'll probably have better access to your state senators and congressmen than your senators and congressmen on the federal level in Washington. And the other side can argue in this specific case that these state laws, having different state laws, actually end up hurting the poor, as we mentioned before, because people who can afford it will just simply go to a state that allows abortion and get the procedures there and come back, while the people who cannot afford it will not have that kind of privilege. In a quick review of the three branches of the federal government, you have your executive branch, which is the president, and then the legislative branch, which is your Congress made up of senators and House of Representatives, and then the judicial branch, which is the Supreme Court. And in a simplification, legislative branch makes laws. And the check and balance the judicial branch has over the legislative branch is to determine whether those laws are constitutional. And this check can make the roles of these two different branches a little murky, because the Supreme Court ruling can essentially end up creating a new law. For example, technically, Roe v. Wade just stated that bans on abortions were unconstitutional. But indirectly, it kind of created a constitutional law that wasn't recognized before. Now, this brings us to the next issue of how should the Constitution be interpreted? How do we determine whether something is constitutional or not? Well, depends on who you ask. Laws are very arbitrary. Just go read the constitutional amendments. Let's look at the 14th and 9th Amendments that were used to defend Roe. The 14th Amendment reads, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law." End quote. The due process clause has been interpreted by many to mean that citizens have a right to privacy, including medical privacy. The 9th Amendment reads, quote, "The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." End quote. Basically, it's interpreted to mean that people aren't restricted only to the rights explicitly stated in the Constitution, but have other rights as well. So these are all fairly vague, and I don't say this as a knock on the founding fathers or anything, because, this is what was intended. No one knows the future. You can't have a law in place for every new situation that might arise. So this is why we're able to create new laws and have a justice system which judges to interpret the laws. And when it comes to interpreting the Constitution, there's basically two main camps in the legal world. And one is called originalism, and that's when they believe that everything in the Constitution should be taken literally. So exactly what the text says. And if it's not in there, doesn't count. And the other side is called living constitutionalism. And they see the Constitution as a living document, and the reading should change with the times. And so obviously you can't have these interpretations be changing all the time. So that will create chaos. And that's why in the Supreme Court, there's this idea called the court's precedents. And what that is any ruling from a previous case usually gets upheld. So the ruling of a certain issue, extremely rare that it gets overturned. And that's why a lot of people were so surprised about the Dobbs case, because Roe v. Wade's ruling has had precedence for the last 50 years that's been held in the Supreme Court. But the majority opinion in the Dobbs case argued that the ruling in the Roe v. Wade case was wrong to begin with. They say a constitutional right was wrongfully created out of the vagueness of the 14th and 9th Amendments. They say that if a right were to be construed from these amendments, then it must be, quote, deeply rooted in tradition and history, end quote. And continued saying that when the 14th Amendment was adopted in 1868, there were 36 states that limited abortion. Yet there were no mention or provision of this in the 14th Amendment that overturned it. But the counter to that can be, well, the time when the 14th Amendment was adopted, segregation was also legal, but we're obviously not going to bring that back. But the counter to that can be, well, the legislative branch created the Civil Rights Act of 1964 and made it into law that banned segregation instead of relying on the Supreme Court ruling. In any case, this still brings up the concern that other rulings based on the 14th Amendment would come into question, such as the Obergefell versus Hodges, which gave the right to same-sex marriage, or Griswold versus Connecticut, which gave the right to contraception. The majority opinion still says that no, those will not come into question because this Dobbs case is a special case, and this is only specifically for abortion because it threatens another life. But if you see Justice Thomas's concurrence opinion, and a concurrence opinion is when you agree with the majority's decision, but you have a different reasoning behind it, he explicitly states those two other cases and says that those should also be looked at again. But he left out another case which had its ruling based on the 14th Amendment, which is Loving versus Virginia, which gave the right to interracial marriage. And it just seems convenient that he did this because Justice Clarence Thomas is a black man who's in an interracial marriage with a white woman. So he's cherry picking. With that logic, every case that relied on the 14th Amendment should be in question. He must know that if those two cases are in question, so will Loving v. Virginia. But maybe this is his whole scheme to get out of his marriage. Oh, sorry, honey, it's not you, it's me. I mean the law. But I don't know, just kidding. I'm sure that they're in a happy marriage. But anyway, so going back to the idea of people being surprised about the Dobbs case, about how Roe v. Wade was overturned. But there was actually a lot brewing under the surface for a while. So, we should talk about the lead up to the Dobbs case. There was a case in 1992 called Planned Parenthood versus Casey. And for the general public, it was known to be the case that upheld Roe v. Wade and kind of solidified that abortion was a constitutional right. But if you look into the details, that's not really true because it was more of a win for both the pro-life and pro-choice movement. And how could that be? Well, while it did uphold Roe, it allowed states to restrict abortions as long as there was an undue burden on the patient. And undue burden is just like how it sounds. It is pretty vague, but we'll actually come back to this later and see the consequences of this ruling. In regards to the restrictions, it was things like waiting periods, which is when after a patient and physician agreed to go ahead with an abortion, they had to wait a day or two or whatever the state law was to actually go through with it. Another restriction could be minors were required to get parental consent. So it did solidify Roe, but it left the door open for the pro-life movement. Now let's fast forward to 2008. This is when the Democrats were basically winning everything. Obama just got elected. Democrats controlled both Senate and the House. There was a strong support for abortion rights in Congress. And Obamacare, or the Affordable Health Care Act, was getting pushed through. And along with that, they were trying to get basic medical insurance to cover abortion. To be clear, I don't want to mix up the Republican Party with the pro-life movement too much because there are Republicans who are pro-choice, and vice versa for the other side. There are some Democrats who are pro-life. But pro-life candidates are most of the time Republican because if you had that platform as a Democrat, it would be nearly impossible to win. Okay, so coming back to the story, the Republicans basically had to go back to the drawing board and they had to come up with a new strategy. So their new strategy was instead of looking at the federal elections, which they were having a tough time competing in, they were going to turn their attention to state elections and controlling state governments. So they completely focused on the 2010 midterm elections. Another reason why 2010 was so important was because it was a census year, which means that the winner gets to redraw the congressional districts. In other words, gerrymandering. And we'll actually cover that topic in another episode, but basically, whoever came into power that year will also be able to remain in power. And the strategy worked. There was a huge red wave in the state elections. The pro-life movement was also really hard at work, and they were able to elect many of their candidates into office. And the way they did this was the pro-life movement had strong presence of lobbyists on the state level. But the pro-choice lobbyists weren't really present in the state government, but they were focused on the national level. Now, with the Republican Party controlling most of the state governments, over the years, the pro-life movement was able to push more and more of their candidates into office. So remember when we talked about the undue burden clause from the Planned Parenthood case and how it left the door open? Well, this is when it comes into effect. The state pro-life activists and legislatures start to add more and more restrictions, like increased waiting periods after a doctor consultation, and no abortion just because you don't like the gender of the baby. Granted, some of these sounded like good things, but it just continued to question the validity and the strength of Roe v. Wade and starts slowly changing. And then over the years, once the Republican Party began to control the national level, they started getting the Supreme Court packed with right-leaning justices. And this is when the state laws became more aggressive and just outright violated the rulings of Roe v. Wade until it got sent up to the Supreme Court. And that's how you ended up with the Dobbs versus Jackson's Women's Health Organization case, and eventually Roe v. Wade was overturned. If you're on the losing side of this, you're probably listening to this and thinking, oh, those conniving Republicans. But if you take a moment and think about the other side, if you're on the winning side, you're thinking, wow, that was a great strategy and it worked. And they worked really hard for this because they've been on this losing end for a really long time. And it took a really long time to get to this point. And let's just be honest, one side is not necessarily conniving. Both sides play this game. It just so happens that the right won this time. And the pro-choice movement probably relied a little too much on the Supreme Court ruling, but should have been pushing the legislative branch to make it into law. But granted, in this system, it is extremely difficult to get the Constitution amended, especially with the filibuster. But either way, I don't want to make this so much about left or right, because there are actually a lot of Republicans who are for abortion. And so I'm just going to zip through some data, some polls that actually may surprise some of you. So this polling was done by the Pew Research Center in 2022, and it showed that 80% of Democrats believe that abortion should be legal in most or all cases, while 18% believe that it should be illegal in most or all cases. if you're wondering why it's not adding up to 100%, it's because 2% had no opinion, and that's true for the other ones going forward, so I won't mention it. So for Republicans, 38% believe that it should be legal in most or all cases. 60% believe that it should be illegal. What I found a little more interesting was people who identified themselves as moderate Republicans, majority of them believe that it should be legal, about 60%. And then 38% responded saying illegal. And then for women, 63% of women believe that it should be legal in most and all cases, and 35% believe that it should be illegal in most and all cases. So this does, to a certain extent, debunk the idea that if you're pro-life, you're misogynistic, because while obviously it's not the majority, but 35% is still a significant amount of women who believe that abortion should be illegal in most or all cases. Okay, so moving along, this next set of surveys was done by the Gallup poll in 2022. And for the overall population, it showed that 35% believe that abortion should be legal under any circumstances. 50% thought it should be legal under certain circumstances. And 13% believe that it should be illegal under any circumstances, and 2% with no opinion. And in the next poll, it shows how Americans feel about abortion in different stages of the pregnancy. So in the first trimester, 67% believe that it should be legal. But that number declines dramatically in the second and third trimester. In the second trimester, it being 36%, and then the third trimester, it falls down to 20%. Again, this is showing that this is not such a black and white issue, and people are not just either for abortion or against abortion, but there are more nuanced opinions, and people have different opinions depending on the situation. Of course, there are some cases that are really clear, such as 83% of Americans believe that abortion is okay in cases where the mother's life is endangered, and then 77% are okay in cases of rape or incest. And some other interesting stats from the CDC, the number of abortions have actually been declining in the last 30 years, where it peaked in 1990 with about 1.4 million cases. And by 2020, that cut by more than half, with 600,000 cases. And 56% of those cases being done by surgery, while 44% are non-intrusive, meaning you just take a pill. And lastly, just a couple more stats comparing abortion in 1972 before Roe v. Wade and now. In 1972, about 41% of abortions were held outside of the patient's state residency, and in 2019, that was about 9%. But I would imagine that this number is going to be a lot higher in the following years now that a lot of the states will have different laws. And this goes back to the idea of people having to travel to another state, and there will be people who will not be able to for various financial reasons. And one more is in 1972, there were about 35 deaths from illegal abortions, and pretty much in the last 40 years, most of the years were 0. In summary, most Americans are actually for abortion, but with some restrictions. It's not as divided as most people think. It just so happens that the extremes are the loudest, as in most cases. And there are these simplified narratives out there that are thrown around by the media that feed into this anger and causes us to demonize the other side. We almost see the other side as these one-dimensional Disney villains or something, but as we've shown, most people are actually somewhere in the middle, and there are a lot of nuanced opinions out there that take into consideration a lot of different factors, not just the morality issue, but the legal or medical issue. And just because we present a lot of different viewpoints doesn't mean that you should have no viewpoint or no opinions, but this is to help us to gain different perspectives and so that we can understand each other and see each other as people in order to untie and unpack this complicated issue. And that's the hope. So this is the third stage, and for today, this is where we leave it.